Hello, everybody. Hello, Nana Laura. Hello, C-Rex. Oh, I can change this. We're not dealing with a soft sit today. Hello, Cassie Battles, honey. I'm so happy you made it. Hello, Catherine Gaston, sweetie. Hello, Manuel. Hello, Amanda Roderick. Thank you so much for being here. Ava came out from under the desk just to greet you and to get her treats. That's, that's the thing. Oh, thank you so much. I appreciate that. Life's been lifing me hard lately. I haven't been able to do as many replay crew minis. Plus, like, for some reason, the quality of the videos, like, I don't know what is up, but I don't know if my Wi-Fi is not strong at night lately or what, but it's just not been, it's been dumbing down the quality, and I don't like it. Java 64, hello. I love your name. Because this is always filled with Java. Hello, baby girl. Hello, Spider-Man, honey. So I came on early tonight because tomorrow is my best friend's birthday, and I got their presents wrapped, and I made a cake. I have to frost it still, but it's in the refrigerator, and then I have to give it to them. So I wanted to spend time with you guys, but I also have to spend time with them, maybe. It looks like they might have company, so I don't know. Oh, thank you so much, honey. I appreciate that. Absolutely. It's life's blood. Just give me an IV straight to the veins. And I'm good. I'm good. So yeah, we're going to go for the majority of the night. We're going to go to Bellingham, Washington. We call it church court because the courtroom looks like a church that's just been repurposed. We used to talk about how they would have bingo on Thursday nights, and how they, the elementary school Christmas play would happen there, and it's so much fun. It's so much fun. Hi, Earl. Oh, and by the way, Sandy Hurd was the only one that responded, so I didn't need to do the spinny wheel thing. So Sandy Hurd, send me your address, and you'll get the Crying Fez t-shirt sent out to you. Hello, Buzzy Pug. Hi, Megan Rindell. So good to see you. Don't let him fool you. He had some. He really did. Oh, honey, you are just too sweet to me. I do have treats for Earl, though. I do. They're right here. He's just got to come get them. You want some? The rules are the rules. You got to come be on camera if you want your treats. That's a good boy. That's a good boy, Earl. Hello, Wendy A. I I'm so happy you came. Terry Barnes with the big Kentucky hugs. Hello. Oh my gosh, thank you so much. I appreciate that. We absolutely love everyone here. Everyone is welcome, and we just have such a great time together. We do. Oh, my daughter gets this stuff called True Fruit, and it is fruit that is dipped in white chocolate and then dipped in milk chocolate, I think it is, or dark chocolate. I think milk. It's milk chocolate. So it's dipped in white chocolate, then dipped in milk chocolate, and then frozen, right? And you pay like $7 for this bag with like this much in it. You get maybe six strawberries, maybe like 20 raspberries. I don't know. You pay a lot. It's a lot. You could make it so much cheaper at home, but it's the convenience of it. It is fantastic though. It's called True Fruit. I would really love to be able to come on this early more often, but unfortunately, to get enough content together for a live stream and do all the replay crew minis and everything like that, I'm still working on it at 11 o'clock when I'm posting the thumbnail that I'm going to go live. There's just not enough hours in the day. I try, but yeah. I'm jealous. It's almost like you get 2 more hours than me, but that's not even the case. It just feels that way. But yeah, I would love to come on this early every day. And maybe someday I will be able to. I just have to, rearrange my sleep schedule and all of my, appointments and get all cat boxes done earlier. And yeah, there's a lot. Plus my kid's home from college right now. She'll be gone soon. And then it'll be back to just me and the pets. Maybe then I can go early. I was going to do that the last time she went to college. Didn't work out. I was also going to do 2 live streams a day. Didn't work out. Oh yeah, they're so helpful. Billy is the most helpful of all of them because he's the one that sits on the keyboard while I'm trying to edit. He actually does. He puts his head on my hand and his body on the keyboard, and he does his little kick thing to make sure that all of my editing gets screwed up, and I have to hit the back button about a dozen times and redo my work. And yeah, he's very helpful. They really are. Ava is kind of the boss around here. She keeps me in check. Oh, thank you, sweetie. I have my moments. I'm not a soloist funny person. I'm just not. I'm not funny on my own. I work best in tandem with other people's comments. Like I'm quick-witted and I can get comments in there, but not without the help of others. I need a I'm not a wingman. I need a secondary, person to help me. That's the only way I can be funny. Oh, I have. I have let it go before, thinking it was okay. Thinking there's no way he could have changed anything. It was on a Judge Mogan docket, Burnett County, Wisconsin. I remember it. I was streaming it, and it worked out. Nobody noticed. but a chunk from the middle of when she was admonishing the defendant ended up getting put at the front. So it was almost like, you know how Squishy starts his streams with like the coolest part of the show? He does like a little mini trailer almost, but then he plays the whole entire thing. It was almost like that. She was admonishing the defendant, and then it went into the hearing, and it just happened to work out in a way that you didn't notice the piece was missing, but it was in the front. I was mortified when it happened because I knew that it was screwed up, but nobody else noticed. And then I fixed it for the replay crew. Oh, I love Monty Python. Yes. Maybe that's where I get it from. Yeah, you don't even know. No more hobosexuals for me. It's funny. I went out and got food for me and Kendra, and that's where Kendra wanted food from, was where he works. And I saw a kid. I used to live with his grandma, and he works there. And I sent his mom the graphic that I had made that says my freeloading ex is now a hobosexual. And so I had sent that to his mom the day that I made it. And then several days later, I see her son working with him. And so I sent her a text, and I'm like, oh my God, your son is working with the hobosexual. She's like, he wants to know the name. Oh my gosh, that's amazing. I do too. I live in Toma, but I was born and raised in Baraboo. Absolutely, she can be. And one of the videos that I have, it's an older video. The defendant is actually she's $72,000 in debt from defrauding a church. And so she's been having to make payments the entire time, and the director of the church was not happy because she was getting off probation. It wasn't fully paid off yet, and he refused to give her any grace and give her any, the fact that she had made it all these months on probation, making very large payments every month successfully, and he just couldn't accept it because it wasn't paid off. And Judge Mogan came down on that church person very hard and used scripture even. And she didn't like bringing scripture into the hearing, but she almost had to. She had to use his tools against him. And it was an amazing hearing. It's very far down in the Replay Crew mini playlist, but I remember it has purple lettering, and it talks about, the woman and the $72,000 in debt with the church. But I highly recommend you go see it. Maybe I'll put the link in the description now that I've talked about it. Yeah. It might be the way to live. It just might be. Because every time I fall in love, man, I get my heart broke. Hard. See? It was a good one. It was a good one. I'm not going to argue with you there. I have to edit it a lot. I have to cut out time spaces and yeah, I just sometimes I've actually passed up some of her hearings just because I can't listen to her sometimes. sometimes. She's good. She's good, yes. I don't run her often. I think I have in the past, though. I knew what you meant. We all knew what you meant. We don't judge spelling and grammatical errors here. We just don't. We all make mistakes, and it's perfectly fine here. Hey, Jerry Matthew Boyd. You know, I was waiting for you. I wasn't going to start the cases until you got here. All right, guys. Let's have some fun. It's a very long one, and I did throw in a Michigan also. Oh, I love her. Absolutely love her. I think she is so gorgeous, and her personality is amazing. I love the gardening with the judge thing that she does. She's great. I wasn't going to say it. Nuh-uh. Me, I'm innocent. I am innocent and as pure as the fallen snow. Yeah, and April is very, very good about translation. Sometimes I'll put the comment up and it'll be, you know, kind of word salady, and I will respond to it and make sure I clarify it. That's me right there, the fallen snow angel. Yes, your phone does miss text all the time. I just had to use that as an example. See, I love you. Oh my gosh. I got a picture message from S. Buford earlier today. In South Carolina, it was 100 degrees. Here, it's just the humidity. I have the air conditioner going. It's 82 degrees, but somebody won't let me close the window. Will you, Bandit? I've been trying for the last half hour to close this window. I've got it all but this far, but she will not come out of it. She won't come out of it. I've tried everything. I've tried treats. I've tried cuddles. I've tried everything. No. I don't care how hot it gets. I don't care. I don't want winter back. No. Keep it. Yeah, that's about what it is here, but it's so humid. I just got out of the shower, so it's a little misleading, but my hair won't do anything that I want it to because it's so humid out. Oh my gosh. That's me right there. Spring or fall? I'll take fall. Fall's pretty darn good. That's on its way. It's coming. I love to look at it. That's about it. I don't love to have to shovel it. It's just, it's cold and wet and heavy. You can keep it. You can have all of mine. Not here. Not here. Oh, I know. If it ain't the kid or the roommate, it's the animals. Man, Oh, it's what I gotta do. Hello, isn't that special? You sure are special. I think it's mine too. I really do. My birthday's in the fall. What can I say? Jerry, I love you, and I'm doing all I can, buddy. You got me. You got me with that one. Human cycling? Are you talking about like our body's rhythm and like how our sleep schedule and everything? Because I don't think you're talking about like bicycling. Thank you. See, every time I learn just a little bit more. Because now that's translated, and now I can close the window. Hello, she's a maker. Welcome, honey. Yes, I got it closed. Yes. All right, guys. Ouch. Sorry, I'm getting tased now that I closed the window. So yeah, I'm gonna put. Oh, that's not what I meant to click. Sorry. The jolts are intense. And they make me look funny. Hi, baby. Oh, I love you so much. You are the bestest. Absolute bestest.
Okay, Miss Liu, who else is ready to go?
Yes, Your Honor. I just want to confirm whether James Power is still here. He has another client, Lennox.
If he's not, I'll speak for
He's
myself.
here.
If not, I will speak for myself.
Lennox
I do not want to
Johnston?
wait.
Yes.
He's not in Zoom. Okay. All right. Well, I guess we can just take that one. Are you ready on that one? Otherwise, sure. Lennox Johnston.
Yeah.
All right. Morning, Mr. Johnston.
Morning, Your Honor.
Give me just a moment, sir. Let me call the cases here. 580376225, 580451837, 580561559, and then 580155492.
Multiple cases. Is that all that I'm dealing with prior to this?
Okay. Hold on.
Yeah, the city's asking to review his release on all those since, so I've asked those, I had Madam Clerk to add those since the court finds probable cause in the newest one to be a violation of his release on all the others.
All right, and then we do have, well, I'm gonna do a couple of things here. First, I just need to confirm, because I didn't even see, is Mr. Powers the attorney of record on all those?
Well, he's not on the new
On
one.
all of this, not a new one.
Okay, yeah, on the others. Okay, I do see that there. Okay.
Your Honor, the new one needs to be struck, and the old ones do not need to be renewed.
Hold on, sir. Madam Clerk, can we, I mean, we really need to have Mr. Powers here. Is there any way we can just put this and then, because there's a lot going on with this.
Sir, I do not think you should represent yourself. They're trying to get his attorney to zoom in.
See if he can zoom back in. Yeah, I think what we're going to do, Mr. Johnston, you really do need to have counsel here. They need.
Can I speak, Your Honor?
They need to be present. You can certainly speak, but I'm going to, basically, we're going to reach out to Mr. Powers and see if he can appear here on your behalf.
I understand.
We still got numerous other people to get through, so.
I understand. My cats have been locked in a kennel since I got arrested. I did not commit any crime. I did not violate any order. I did not do any of that. And if you contact the, protected party, I have been informed by James that the protected party has both called in and let the police or the prosecutor or whoever know that, one, they never interacted with me yesterday, and two, the
Johnston,
accusation of me following them didn't happen.
Mr. Johnston,
They also
I wanna
put in a
be clear.
request to
Sir,
rescind the order.
Stop talking for a second. I'm hearing what you're saying, but I need to caution you. You are talking about the facts alleged here. You are being recorded. Everything you're saying, the city attorney can come back and they can use it against you at a jury trial. I would highly, highly recommend you don't talk about the facts here. Here's what we're going to do.
I understand.
We're going to foot your matter. I'm still going to hear you this morning, but we're going to try and reach out to Mr. Powers, see if he can appear on your behalf. And then I'll recall you once hopefully Mr. Powers has returned. If he's not able to,
If he doesn't,
then we'll address it either way. My preference would be to have your attorney of record here to handle your matters. So
I just need to state that this new charge needs to be dropped. The protected party wants to rescind the order. The protected party has come out and said that this charge is false.
Mr. Johnson, we'll go through all this once your counsel's here, and we'll go through it piece by piece. But at this point, please just take a seat, and I'll recall you once we have Mr. Powers.
Thank you, Your Honor.
All right, Ms. Lee, was anything else ready to go? Okay.
And the only lost person is Johnston Lennox.
Okay. And Madam President,
Did Mr. Wilder, sorry, and Mr. Kilfoyle is going to handle that one because that's his case, the
Okay.
Johnston one. Wilder was the only one I was on here. I'm sorry, did we just address that? Is he not appearing?
No, I'm not sure. Are you still waiting on Wilder, you said, counsel?
Yes, Your Honor.
Okay.
We're
If you
still
want to go ahead
waiting
and
for
handle
him.
that Johnston one, then I'll return for Wilder.
Okay, let's recall then the
Probation
Johnston matters, and then
Probation,
Madam Clerk,
just-
I'll just confirm Mr. Powers.
It's complicated. Sounds good, thank you.
Okay. All right, well, I guess there's a couple of things that we need to do here today then. Let's start with the arraignment. Bit of an odd one here. It looks like the ticket got filed under the a totally incorrect name. It's Sage Johnston Lennox Edison, which is obviously.
Your Honor, may I speak for a second?
Hold on. You're going to get a chance to speak, but we need to go through some procedural things first. So, Mr. Kilfoyle, I see the city's moving to amend that to obviously the defendant's correct name.
And Your Honor, I'm playing a little bit of catch up here as I wasn't to be on the calendar this morning, but the city would so move if the citation is incorrect.
Okay, that's just a procedural thing. I'm going to grant that because obviously we need to have the name corrected. So that's all that's functionally doing, sir, is just correcting your name to now reflect Lennox E. Johnston.
And Your Honor, on my end, it doesn't look like an order on motion has been uploaded. Does the court need me to upload an order on motion?
Oh, it's because it's under Edison because that's
Okay.
what it was.
Gotcha, okay.
And, yeah, that'll reflect it to Lennox Johnston. So
Thank you, Your
and
Honor.
Mr. Anderson did sign it, so I'm going to sign off on that. So, okay, now that that's addressed, Mr. Kilfoyle, I presume you'd probably like to address the arraignment first, and then we can go through everything else.
That is correct, Your Honor. I don't know if we need to go through the formal reading of rights. I don't know where we're at procedurally. I know this case had been called and then set aside.
Yeah. So, Ms. Liu, your office is not currently assigned, obviously, on the arraignment, and it sounds like the other cases were conflicts. Is that correct?
Yes, Your Honor.
Okay.
I was formally written my rights, though.
Okay. So here's what I'm going to do, Mr. Johnston. I'm just going to read through your rights and the charge with you on this. We'll do this the old-fashioned way. I'm just going to go through everything on the record. And then at that point, I can obviously enter a not guilty plea on your behalf. So let's start first with the charge here today. It is one charge, protection order violation, domestic violence. I understand from what you told me earlier, you don't agree with the charge, and we'll get to all that in a minute. But right now, the court does find probable cause for the charge. I did review the probable cause statement. I think there's enough there for PC. That charge is somewhat self-explanatory, Mr. Johnston. It's just the allegation is that you knowingly violated a valid protection order.
But
And I understand you're going to get your chance to enter a not guilty plea. I get all that. I'm just telling you that's what the charge is. As far as going through your rights, I'm just going to read them to you. I just want to make sure there's no gaps here, that everything's been covered. You do have the right to be represented by counsel. Ms. Liu can stand in for the moment, but as she's already noted, your case is a conflict for their office. So I'm going to assign you Mr. Powers on this case as well. He'll be assigned to these matters. You are presumed innocent of the charge, sir, unless and until it's proven beyond a reasonable doubt. You do have the right to a speedy trial. You have the constitutional right to a jury trial unless you specifically waive that right. You have the right to see, hear, and question all witnesses who testify against you. You have the right to call witnesses on your behalf and may have the court subpoena them at no cost to you. You have the right to testify on your own behalf. You also have the right to remain silent, and your silence cannot be used against you. If you're convicted after entering a not guilty plea, you would have the right to appeal that conviction to Superior Court within 30 days. And lastly, Mr. Johnston, if you were not a United States citizen, then conviction of this crime could carry negative immigration consequences. Now, without getting into all the other stuff for the moment, any questions at all about your rights?
No, Your Honor.
Okay, I'm going to go ahead then. At this point, Mr. Johnston, I'm going to enter a not guilty plea on your behalf. That certainly preserves your rights and defenses in regard to this charge. And I'll hear from you in a minute. First, I'm going to hear from the city attorney. Mr. Kilfoyle, would the city like to address conditions here?
Thank you, Your Honor. And Your Honor, I'm just addressing this arraignment case right now. At this time, based upon the information that I have, the city is going to be asking for $1,000 cash or court-approved performance bond. I would also be asking for a DCR evaluation based upon the alleged facts from this case, as well as all the other cases. I would also be asking for pretrial monitoring through the behavioral health unit as well. I'm not asking for an additional no contact order at this time, considering that we already have an underlying one, which is why we're even here to begin with today. So that would be the city's request. I can go through the defense history, but I'm pretty sure it's pretty self-explanatory to the court as to why the city's asking for this much bail. All of these cases are within the last couple of months. The earliest one is from April 27th, and then we've now had 4 new violations and new criminal charges since April.
All right. Now, I'm just checking. I do need to check one thing. I'm seeing a note. I'm kind of backtracking here to the other cases because I kind of want to see where they're at in terms of bail. It says that there was allow a month to post previously ordered bail, and I'm just seeing what was the previously ordered bail on that.
I believe it was $250.
$250. Okay. Okay, Ms. Liu, does defense wish to be heard at all on the arraignment?
Yes, I do.
Okay, Mr. Johnston, I'm just going to remind you one more time, please don't talk about the facts alleged here. Everything you're saying is being recorded. Everything can be used against you. What is it you'd like
I understand
to
your. I want to say first and foremost that I understand that initially there were complications, specifically with me getting the GPS monitor, but I have got the GPS monitor and I have been cooperating fully with the courts. I have been going to therapy and taking medication, and I have been abiding by the no contact order fully and completely. What was it, yesterday? The night prior, my grandfather died. My grandfather passed away. I spent that morning on the phone with my mother, loudly crying. And then when my mother told me to walk to the park to calm down, I got arrested as soon as I left my door. The pretense of this charge is that there was a noise complaint that I was arguing with somebody. I was on the phone with my mother. My grandfather just died. On top of that, my cats are still trapped in their kennel at my house. I firmly believe in my heart and my soul that I have been doing everything I can to cooperate and to do this the lawful way. I did not violate the order. I know that the protected party, once they found out this happened, went and reached out to, I don't know if it was the prosecutor or the victim's advocates, but they reached out to somebody and they let them know, hey, he didn't violate this and I want the no contact order rescinded. All of that being said, I just want to go home today. I need to take care of my cats. I'm very, very concerned about them. I need to grieve. And I will continue to cooperate with the court. I will continue to go to mental health therapy and psychiatry and continue my medication. And I will continue to follow the no contact order. And if you want me back on GPS monitoring, I will continue to do that. And I will pay the $250 bail. But I am unemployed and I am on ABD, and this prevents me from employment. This prevents me from sitting at this whole situation also makes me, even if I could, makes it very hard to get employment. I'm unemployed. I have no income. The very little income that I have comes on the first, and it is already pretty much all going towards the $250 bail. So I ask from the bottom of my heart, human to human, I am going through a lot right now. I did not commit this crime. I would like to get sent home with little to no additional, what's the word, nothing, I don't want anything new added. I don't want to have to get another monitor or a longer and I especially do not want more bail. I am so broke and it is causing me so much stress just having to pay this $250. I will do anything else. I will take classes. I will do consistent probation. I am open to cooperate with the courts. I just have to say that I did not commit this crime. This is a misunderstanding, and I have been cooperating, and I would love to go home as soon as possible because I'm trying not to cry. I'm very worried about my cats.
Okay. Mr. Johnston, thank you very much, sir. Really sorry to hear about you said was your grandfather?
Yes, Your Honor.
Father. Sorry, I mean, that's a tough situation. I understand you're going through some stuff right now.
I pretty much just got the news, and then I got arrested.
Okay. Well, that's a distressing situation, so I very much understand that. Before I make any decisions, one more time, is there anything else from the city, Mr. Kilfoyle?
Your Honor, I understand that there's a lot going on in Mr. Johnston's life. However, we do have now 4 allegations of domestic violence crimes. That's all the city wants to say.
All right. Mr. Johnston, you've really put yourself in a difficult situation, sir, because what the court goes off, charges that are pending. The court goes off of the report that I have from law enforcement. Obviously, you'll have every opportunity to refute that report from law enforcement, but right now, the only sworn testimony I have is from Bellingham Police Department, and the court has found there's probable cause for this charge. As the city attorney noted, this is now a 4th pending domestic violence charge, Mr. Johnston, in a matter of about 3 months. We have the underlying assault and now 3 subsequent protection order violations. You were PR'd initially. I think you were maybe even PR'd on the first protection order violation. And then with the second one, there was 250 ordered. Now we're on a 3rd.
But wait, the victim, she said she wasn't there, according to him. And he knows that she rescinded the no contact request. So, I mean, according to him, but he's not having contact with her. He just knows that she called and told them she wasn't there during this incident, and she requested that the no contact be lifted. So, but he's not having contact. He didn't do it.
I cannot justify a release, Mr. Johnston, on a 4th pending domestic violence charge.
Please, Your Honor, may I please try to convince you otherwise?
Mr. Johnston,
I will do home monitoring. Can I do home monitoring?
Mr. Johnston, I've heard from you, and I understand where you're coming from. You have to understand, 4 pending DV charges, I cannot release you without bail. The court is finding that. So hold on, Mr. Johnston. I've let you speak. Now let me speak. The court is finding that there is, at this point, there is a risk that you'll interfere with the administration of justice. 3 pending VNCOs is no contact order violations is very concerning to the court. The court's finding there's obviously been violation of the pretrial release conditions on those previous 3 cases. So I'll set it. I'll allow a 10 times bondable amount, but the $1,000 the city's requesting, it's granted. And Mr. Johnston, I'm sorry the situation.
So I have to pay that to get out?
So $1,000 would be the cash amount, 10 times bondable. So a $10,000.
What does that mean? What does 10 times bondable mean?
It means that you could bond out on $10,000. So basically,
I'm unemployed. I don't know anybody that has money.
So the difference between a bond and the cash is a bond means that a bondsman will put up the money for you, usually with some sort of agreement between the two of you. That's between you and the bondsman. I don't play any role in that. The cash amount would be if you just want to post the cash and get the cash back upon resolution of the case. So that's going to be the court's order.
if I could do anything at all, home monitoring and mental health stay, I understand that there were violations prior to this. But I have to explain those were misunderstandings. The first violation was for my ankle monitor because I got it a day late because I wasn't able to get there before they closed, and I immediately got the other monitor.
Okay, Mr. Johnston, I understand.
And this violation, I didn't do this.
Hold on, I understand that you're stressed out. I get that, but what I'm doing here, I need to go through the order with you. The court, based on all the information provided, I am finding there is a nexus between behavioral health issues and the allegations here. I think that much has been made clear. I'm going to place you on pretrial supervision with the behavioral health unit, and I am actually going to order a DCR evaluation prior to any release from custody. That's called a designated crisis responder. They just talk to you to make sure that, frankly, you're doing okay and that you're not a threat of harm to yourself or others.
The main crisis right now is those cats in that kennel. That's what needs to be addressed.
I need to go home today, Your Honor. I need to go home. My cats aren't safe.
Johnston, I understand that, but at this point, given 4 pending DV charges, I'm not releasing you on your personal recognizance. I am finding you eligible.
Can we do home monitoring?
At this point, sir, no. I understand your position, sir. I understand it very well. 4 pending DV charges.
But I didn't do this. I didn't.
Hold on. Let me get through the order, sir. I understand this is a stressful situation, but I need to get through this. Other conditions.
Will I be able to pay the bond today and go home today?
No new criminal. Yes, if the bail or bond is posted, you'd be released today. Have no new criminal law violations, and most importantly, abide by all active no contact orders. I am finding you eligible for the public defender. We'll get you an attorney assigned. It likely will be Mr. Powers. And then, Madam Clerk, I'm going to set, well, the in custody will be August 4th, 8:30. But Madam Clerk, what's the out of custody? Does you have an out of custody date already set?
I only have one free call, and I need to. Your Honor, I will do anything. I will do anything to go home.
All right, I'm going to set the out of
Please,
custody
this isn't
on
right. Your Honor, I beg you.
Hold on,
My
sir.
grandfather just died. My cats aren't safe. This isn't right. This isn't right. I will do anything. I will do anything I can to get out on PR. Give me a $2,000 bail, but allow me to go home, please, Your Honor.
Well, he's already set for September 21st, you said? 25th, so that's a little over 60 days. Would you be fine setting this one to that date as well, or do you want an earlier date out of custody?
I'd be fine with setting this one to that date out of custody. I do have a request on in-custody dates, but I don't know if the court wants to address that now or after we've addressed the other cases.
Well, I was going to set this one to 8/4, so I guess we better do it now. What date do you want?
Your Honor, I was going to ask for something sooner, maybe only a week out, or I don't know how long it's going to take Mr. Powers to get on board if he is the conflicts attorney. I'm assuming he will be since he is on the other cases. But I wanted to let Mr. Johnston know that I'm going to be sending over an updated offer to his counsel. We might potentially be able to resolve sooner rather than later, depending upon how they want to proceed. But I note that I am taking into account that it does sound like there are animals he needs to take care of as well. So I'm also balancing his responsibilities, but also the safety of the community, safety of himself, with the recommendations here, but also asking for a sooner court date with the hope that maybe we could potentially get this resolved.
You want to do next Monday? Do 1 week?
We can do 1 week.
Let's do 1 week. I'll set it for July 28th, 8:30 in custody. We'll maintain the out of custody 9/25 at 1:30. And sir, you're going to be hearing from counsel here very shortly, I expect. Mr. Powers will be getting your case. I'm going to go ahead and sign off on this. Mr. Kilfoyle, looks like all the pretrial cases were added to the calendar. Did you want to address those?
I did, Your Honor.
Okay, go ahead.
And Your Honor, there was some slight confusion at the last hearing in regards to what exactly was to be requested. It turns out the request that was made by my office was 200.
Your Honor, please.
Hold on, sir. I'll hear from you again. I'm going to hear the city attorney is addressing another issue here.
My understanding, and I'm just making sure I'm on track here, is on the 837 case and on the 225, an additional $250 had been requested, and the defendant had been given a month to post that amount. with the new violation that we have here on the cause numbers ending in 559, 837, and 225, the city is asking for a total for each case to be $1,000 cash for group performance bond, so $3,000 on those three. We do have that theft third under the 492. I'm asking at this point for $250 appearance bond on that matter. It's unrelated to the domestic violence cases, but I do, if he is going to be held, he's already being held on the first arraignment that we just did. I want him to get credit while he's booked.
Okay, Mr. Johnston, city attorney is asking, there's been a violation of release conditions on all these others. They're asking to impose bail on those.
Your Honor, I didn't violate this. I didn't violate the orders, and you already signed off. I didn't violate.
Okay, here we are. Court's finding there's been violations. Obviously, we have probable cause on a new charge. I'll take all of this.
What is the probable cause?
Hold on, Mr. Johnston. Hold on. We're getting way off track here. Based on the finding, there's been violations on the prior pretrial cases. Theft third, I'm not as concerned about that. I'll set it at a very low bondable amount, $250, $25 cash is fine. On Mr. Kilfoyle, was everything a PR except for the $250 on
Please PR me.
I do believe so.
I need to go home. I need to go home.
the 2 protection order violations, and I will give you the $1,000.
I'm sorry, Your Honor, could you repeat those amounts?
I'll set it at 500 on the 2 protection order violations. Since they were PRs, I'll give you the $1,000. That's going to be the court's order. 10 times bondable is fine on all of those.
Your Honor, how am I supposed to do this? This is undoable.
I'm going to wrap this up. I'm going to set the court dates will track. In custody, July 28th, 8:30. Out of custody remains. It's already set for 9:25. And
Please, Your Honor, please.
I think that's it. And Mr. Johnston, you'll need to report to the Whatcom County District Court Probation Department upon any release from custody.
And Your Honor, I don't know if
Please, I need to go home. Please, I need to go.
The state would be requesting a DCR on every single case.
I needed this dropped. What about the protected party put in a request to drop this? The protected party said that they were not there. The protected party.
DCR. Mr. Johnston, sir, I understand you're very distressed. The court's order is going to remain at this point, and I'm going to.
How much bail do I need to pay to go home today?
At this point, well, let me add it up. It would be a $30,000 bond or $3,000 cash between all cases. And that is the court's order at this point. So I'm going to go ahead and sign off on this. And I think that's everything. So thank you very much, Mr. Johnston.
I don't know what to do.
Thank you, sir. All right, I'm sorry.
I need to call the wrong people. I need to call the wrong people.
That's totally fine.
I need to go.
All right, Miss.
And if that wasn't bad enough, now we're going to kind of jump backwards in time. We're going to the 21st. And we're going to see, I put it in here just so that y'all would hear the charges and the court's concerns and things. And then we'll jump forward to the 23rd, which is when the defendant actually appears.
We just have Mr. Wilder there. Is he ready to go?
Your Honor, Mr. Wilder will not come back.
Okay, so I'll just note him as a refusal then. Okay, let me go ahead and call
Yeah.
the cases. Jacob Wilder, cause number 5806903994, 5803493225, 5805462990, 5805634555, 5805647333, and 5806729196. 2 of these are on for arraignment. The rest of them are in pretrial status, and I think were returned warrants. Or actually, no, but city requested them be added. So, okay, and it looks like perfect. So, Ms. Liu, Mr. Anderson's just rejoining us. He's going to handle these matters real quick.
Yep.
I'll go ahead then, and I'll note the FTA with the refusal for Mr. Wilder. I am finding probable cause on the 196 cause number. I did review PC on that and on the 394. So with that, Ms. Leo, did you wish to be heard on PC at all?
No, Your Honor.
All right, with that PC established, I'll note the FTA and the refusal. Mr. Anderson, would you like to address conditions on all of
Yeah, and I
these?
know there was a hearing this weekend. And it was found, I'm not sure what bail was set at. If, with the refusal, the city has a couple of concerns. One, I guess it almost asked for a no bail hold at least on the harassments. So just so the court's aware, Mr. Wilder was in custody was in court last week, I believe it was, quashing a warrant on 4 pending no contact order violation charges, domestic violence. I believe the court ordered him to post essentially $500 bail on each of those, so $2,000 total, but Judge Lev gave him basically till his pretrial to post, and ordered an ankle bracelet with a GPS monitoring. That was one of the only few items, I think, of clothing he was actually allegedly wearing when he was picked up on these newest charges. Now that we have allegations of him essentially trying to engage in assaults and fights downtown and in other areas of town, the city has a number of concerns. So not only on this charge, but that's why I asked to have that would be a violation of his pretrial release. The city would ask to have that basically, not asking to increase the bail that was already set, but essentially zero at that time. Instead of giving him to pretrial, I think it needs to be posted immediately.
So he was downtown fighting naked with nothing but his ankle monitor on. I mean, at least he had the ankle monitor on, y'all.
So however the court wants to handle that, I would ask that the bail that was already set and that he needs to post on the other pending charges, that essentially that be set now as is in custody, and that on these newest charges, if that is a refusal, either leave the bail that was already set or go ahead and do no bail hold since he's refusing to come to court. But I just think there's a number of concerns for community safety, frankly, and even to some degree, even for Mr. Wilder's safety based on his behavior.
Yeah. Okay. Ms. Leo, did you wish to be heard at all?
No, Your Honor.
All right, couple of things then. I'll essentially maintain the bail that was previously set on the 4 pretrials, but now it's just going to have to be posted. He's going to be held to, so that'll be $500 per on those. Let me get that all entered here. The court will find that defendant has violated conditions of pretrial release on all of those with multiple new charges pending, some of them actually quite serious allegations. All right, so that's there. And then in regard to the 2 new charges, city's preference is just a no bail hold until we see him?
Well, I think so, because I would really like to have the anti-harassment orders put in place if he's refusing, and they are mostly on those 2 charges, but I think at this point that would be the city's request and reset to Wednesday.
Got it. All right, I'm going to go ahead. PC has been established on those new charges. I'm just going to enter no bail holds on all of them. We need to see Mr. Wilder. These are actually pretty concerning allegations, at least from the court's perspective. So, court does make a finding there is clearly a risk of a violent offense being committed. There's a risk of Mr. Wilder interfering with the administration of justice, and there's a flight risk. He has multiple pending assaults, multiple pending protection order violations, multiple pending harassments. It's all very serious. So that'll be the court's order. We'll set everything over to Wednesday morning then. That'll be July 23rd at 8:30. And if actually, no, there's no bail hold, so that's it. I'm not going to set any other dates. All right, perfect. That's everything from my perspective. Ms. Leo, anything else over there that we missed?
No, Your Honor.
Counsel, thank you all. Thank you, Madam Clerk. We can go ahead and...
Your Honor, we can call the cases of Jacob Wilder.
All right, Jacob Wilder, we have a number of cases here, 5A0690394, 5A0349325, 5A0564733. Morning, Mr. Wilder.
Morning.
5A0546290, 5A0563455, 5A06447, oh, those are just going to be repeats. Okay, and then 5A0672196. So we've got several cases on for arraignment. We've got 4 more in pretrial that I believe also have pretrial violations. So let's go ahead. Mr. Lockhart, do you want to start with the arraignments or the pretrial cases?
And Your Honor, if we can address the arraignments.
All right, let's go ahead and start there. So the 2 arraignment cases, that's the 394 cause number, disorderly conduct, and then it looks like the 196, which is 2 counts of harassment and disorderly conduct. I have found probable cause already, Mr. Lockhart. Are you prepared on those arraignments?
Yes, Your Honor. At this time, we are asking to waive a formal reading of rights. He did sign off on those and asked to enter not guilty pleas on his behalf.
All right, thank you very much. At this time, Mr. Wilder, I will go ahead and waive any further reading of your rights and the charges, entering not guilty pleas on your behalf on those new cases. That does preserve your rights and defenses in regard to them. Would the city like to address conditions, Ms. McGrain, I guess, really on all of these? Or I guess let's start with the arraignments.
I think the only cases that don't have bail set, as far as I can tell, are the arraignments.
Okay.
Because they were no bail holds based on the refusal.
Got it. Okay, let's start there.
And I believe bail has been set on all the other ones. So, the city is quite concerned about these cases. I would be asking for, it looks like there was $500 cash performance on the other cases. I would ask for the same amount for these cases as well. It looks like there were previously anti-harassment orders that had been uploaded, but with the refusal, they didn't carry over, so I'll need a minute to upload those. But I am asking for 2 anti-harassment orders with the alleged victims of the harassment charges. And I believe that is the city's request, is to maintain the bail on the pretrials as previously set, but set bail to be similar at $500 cash for performance bond.
All right, let's go ahead then, and I'm going to pull up the pretrial violations. I think we can just address this holistically. So the court did set bail on those when Mr. Wilder had not appeared yet, so I think defense does have an opportunity to address that. But I need to pull up the violations, so let's see what we've got here. All right, so on pretrial, it looks like the violation is just, it's the new charges. So, Mr. Lockhart, are you able to admit or deny on the violations here on pretrial?
And Your Honor, we're asking to enter a denial.
Okay. All right, we'll enter the denial then formally on that. Bail was set at $500 cash performance on each of the VNCOs. I think they were all VNCOs. Each of the other charges at the very least. So, Mr. Lockhart, would you like to address conditions on everything?
Yes, Your Honor. We would ask the court to take into consideration here that Mr. Wilder's not currently employed. He does receive state benefits, and that he currently does have, sounds like a transitional or clean and sober housing here in Bellingham. So we're asking the court to take all of that into consideration. Thank you.
Okay. Mr. McGrain, I'll admit, I read these on Monday, and I simply don't remember them. Can you tell me what kind of the basis of the harassments are at this
Looks
point?
like the defendant was yelling at people at Boulevard Park.
Oh, this is the Boulevard, okay.
Threatened to beat up 2 people.
Okay. Yeah, I'm sorry. I do remember it then. Okay. All right. And Mr. Wilder had been ordered to post. Okay, it's coming back to me. He had been ordered to post the $2,000
on the VNCOs.
out of custody.
Yep.
We simply ordered that at this point he has to post it from in custody as opposed to having time to post it. Okay. All right. Mr. Wilder, in regard to the protection order violations, the court is not ordering any new bail. Judge Lev ordered you to post $500 per charge on that, $2,000 total, and did order that it be posted by, I think, the next pretrial that would have been out of custody. Now that you've picked up new charges, I'm not going to raise that bail on the protection order violations, but it will have to be posted prior to any release from custody. So it's essentially maintaining the conditions on those. As for the new charges, the court is concerned here. The court, I'm looking at the history. We have pending A2.
Wait. Can I talk for a second? Can I speak for a second?
Yeah, go ahead.
This is all me. Can I speak? All right. So, first off, did you just have to suck one dick or a ladder of dicks to get to your seat?
Okay, Mr. Wilder, that's
How
enough.
many dicks did you have to suck?
We're done, Mr. Wilder. We're done. I'm ordering the bail as the city's requested.
What a dick.
Court does find that there's clearly a risk of a violent offense. I think there's numerous protection order violations. There's clearly a risk of him interfering with the administration of justice, and based on his warrant history, there is a risk of flight. So,
Wait. That guy, he has protection order violations for harassment? I don't buy it. I don't get it. All the dick. Hello, Fozzie in Texas.
we're going to order $500 per charge. 10 times bondable is fine. At this point, I think that, what does that come out to? 1, 2, 3, 4, 5, 6, 7. 8. So either $4,000 cash or $40,000 bond.
Are we considering that
An FTA.
we're gonna need to set the arraignments over, huh? I mean, bail has been set, but
Yeah, we
pleas
will have
been
to set
entered.
arraignments. Yeah, that's right. But not getting through it today. So, all right, give me just a second. Want to try Monday?
I'll defer to the court.
I'm not going to do Friday. Let's try Monday. All right, I'll be a minute. I do need to fill out the order
We
here.
could not delete the anti-harassment orders, and we could
Just
get
leave them.
access them
Sure,
on Monday from today, just so I don't have to do it a third time.
I'm okay with that.
Okay.
Are you fine just leaving them? Yeah, we'll just leave them
Okay,
then.
because I just finished them, so.
Okay. All right. I do need 1 second. I'm sorry, everyone. I'm going to go ahead and fill out the order here real quick.
I think the judge was a little bit flustered and just a little bit, taken aback by this whole situation.
I think they denied him.
I think we did. Yeah, we did deny number 1, Miss Gonzalez Nelson.
Thank you, Judge.
Yeah, I don't think he gets finished.
So you don't think you need to be present Monday?
I think 094 is a new one as well. Okay, there we go.
So the pre-trials are just gonna be set to Monday as well.
Yeah, we'll set everything to Monday morning. All right, so I got to change all these dates then. Sit tight. That's the 28th, right?
Yes.
Okay, and then those are arraignments on the 394 and the 196. All right, Monday, July 28th,
We may get to do this again in a couple of days.
8:30. I guess technically I need to set an out of custody. Do you just want to do at 9:15 on Monday?
Sure.
Okay, that's what we'll do. I am actually going to note an FTA for speedy arraignment purposes. I mean, he left before the hearings were done, so that's noted. Okay, there we go. Signing off on that then. I think that's everything. Anything else ready to go then, Mr. Lockhart?
All right, this is case number 25M00053 People State of Michigan versus Tanetta Murphy.
Morning, Your Honor. Robert Shockley on behalf of
Hey, Ms. Murphy, you're here for a pretrial on operating while intoxicated. Second offense. That matter is a misdemeanor up to 1 year in the county jail, a fine of up to $1,000, and it could be up to 5 days to 1 year in jail. And of course, there's driver's license sanctions as well. Point suspension of license, possible vehicle immobilization. Then you have count number 2, driving while license suspended, second or subsequent offense, 1 year misdemeanor up to $1,000 fine, same type of driver's license sanctions. And count 3, driving an unregistered vehicle, 90 days, $100 fine. So, let's see, you've been here before. Last time was a bond violation, so a couple of times before that, let's see, we had a deviation request. So did we get an answer on that?
the deviation request to reduce it from the second to the first was denied. Today, the people are offering to get the fund straight up to our second home. That's the other.
Okay. So Ms. Murphy, the offer is to plea is charged on count 1, the operating while intoxicated, second offense. We'll go ahead and dismiss count 2, the driving while license suspended, second offense. And the unregistered vehicle charge. So is that what you'd like to do? All right, we're gonna go.
The judge doesn't sound particularly pleased in this situation already.
These constitutional rights here. If you understand the rights that you have, that you're for trial, that you're getting ready to waive, then all you need to do is say yes as we go over these together. And so we're going to start with the fact that, again, you do have a right to have a trial here by judge or by jury with your lawyer representing you. So you understand you can waive that. At trial, you would also have the right to subpoena witnesses. That means you have the right to ask the court to order witnesses to appear testify for you. So you understand you're going to waive that. You have the right to question through your lawyer, witnesses brought against you by the prosecution. You understand you're waiving that. You have the right to testify on your own behalf. But if you chose not to, no one could hold it against you. You understand you're waiving that. Also have the right to be presumed innocent unless proven guilty beyond reasonable doubt by the prosecution. You understand you're waiving that? If you're on probation or parole status now and you plead today, the plea might be considered a probation or parole violation. Understand? And you read and signed a full advice of rights form? Any questions? Understand if I accept the plea today, you will not have a trial. You'll give up the rights on the form. You also understand the possible penalties involved with the charge you are pleading to, with the operating while intoxicated second offense. And you still wish to plead to that charge? Anybody forced with threatened? You been promised anything? Are you pleading freely, voluntarily? You understand if you wanted to appeal something, you'd have to have a right to appeal or request permission to appeal, and you'd have to do it within 21 days. You have to do that within 21 days of sentencing and request a lawyer for an appeal if you want a lawyer within 14 days of sentencing. So you understand that. All right. So did this offense occur? This would have been on or about November 5th, 2024. You were in the city of Southfield operating a motor vehicle on Northwestern Highway, which is a highway open to motor vehicles. Is that correct? And had you had some intoxicating beverage to drink prior to operating the vehicle? And do you remember what it was? Okay, and based upon your consumption of that tequila, did you have a bodily alcohol content of 0.08 grams or more per 210 liters of breath? Remember blowing into a machine and getting a number? Also, 0.126. And were you previously convicted of a operating while impaired driving on March the 27th, 2024 in the 20th District Court? You are satisfied. The court satisfied here factual basis for this plea. Court rules be complied with, and I will accept this plea, finding that it is freely, understandably, voluntarily acting on May and pursuant to the plea agreement. I'll dismiss the other two counts. And so now we're going to have to get a pre-sentence report and an alcohol assessment test. You'll get a chance to review that prior to sentencing with your lawyer. So we need a PSI adjournment for September 5th, 9:30. September 5th, 9:30 date. As far as bond is concerned, here we go. Now we talked about all these missed tests before. She had a bunch of them in May and a positive marijuana, and I said any more missed tests or positive positive levels are not going down, that I was going to change the bond. So here we go. June 8th, no show. June 21st, no show for either test. June 25th, it was incomplete, no sample. June 26th, positive for THC. July 2nd, incomplete, no sample for both ETG and drugs. Positive on July 3rd for THC. Not going down, it's going up. And July 3rd, also positive for alcohol. No show on the night and no show. Does she want to plead guilty to the bond violation? Yeah. Or does she want to have a hearing?
Violations, and she could offer you an explanation.
I would love to hear what that is. So, ma'am, you wish to waive your right to have a hearing and plead guilty? Anybody forced or threatened? Anybody promise anything to? You're pleading guilty voluntarily and freely. So it's true that you had no shows to ever help on June 8th June 21st, twice for the drug and ETG. Incomplete test on the 25th. A positive drug test on the 26th. Another incomplete test July 2nd for ETG and drugs.
I mean, it's kind of hard to deny all that when it's right there on paper. I don't really think the hearing would have been necessary.
Because you didn't give a sample. And then on July 3rd, positive for THC and alcohol. And then July 9th, no show for either test. Is that all true?
There's actually three tests actually taken for we were last year, and we did address that in our last.
No, we did not. We only did 5/9, 5/11, 5/19, 5/31, and 6/3.
I should be seeking judges if that was the order with their last.
I might not have had it then, so might not have been here on the 13th when we did this. So, ma'am, would you like to plead to those? You'd like to plead guilty to all of that I just read? Okay, the investigation basis for the plea to the bond violation. And what is your explanation?
I was facing an eviction. I'm taking care of my nieces and nephews. Also, my cousin just passed away from Johnston. Been all in it. Also, I'm not trying to just give you a whole bunch, but I'm trying to deal with one thing. And right at the time, I feel this, feels like I put it in the wrong time in my life. Let me take care of my addiction, try to look forward to my family status. And more than taking care of this, it should be in this first. Take care of other stuff I had going. Honestly, I'm going.
Well, ma'am, I'm sorry for what you've gone through, but going through something doesn't mean you violate a court order by smoking THC and drinking. There's just no excuse for that. And I don't know why you didn't go to the test, but I told you last time what I was going to do. And I'm a person of my word. Would you like me to?
Oh, no.
Well, you should have been thinking about all of that before you did this. This is no excuse. There's no way I'm going to sit here and tolerate you drinking and smoking weed, hard times or not, death or not. All of these things are going to happen in life to everybody. I don't know, a person here is not going to have somebody they love or care about die. And many people going through financial hardships, and they're not just getting drunk under a court order not to. Are you kidding? And now you're telling me you got a job. What do you expect me to do? Let you walk out of here and say, when I told you last time, if you did it again, I'm changing the bond. I told you up front. There's no surprises here. You should have done whatever you needed to do to deal with whatever it was you were going through, your grief. And I'm not trying to take away from the grief, because I get that part. But I don't know how many funerals I've been to and I never drank for nothing. And I'm talking about relatives, people I love and care about. That's not the answer.
Miss Murphy and I have talked pretty extensively about all the things you've had going on.
Well, so did I last time. I'm not talking anymore. Okay. I need a new PSI date, please, because she's going into custody right now. So we're going to move it up. You're available August 6th, Miss Usman. Okay, we're gonna move that up to August 6th, 9:30. That bond, which was currently is for the next couple seconds, $1,000 personal. It's gonna be a $5,000 cash or surety bond. Go with him. And we'll make sure that probation is going to interview her before. Are we all set? Yes, you're good. All right, next.
Oh my gosh, I love that judge. I do. The audio in her courtroom is crap, so it takes a long time to edit one of her cases, but that was worth it. I just I am a person of my word, she said. And I knew that those cuffs were coming out.
Parker, cause numbers 5A06550008, 5A06550009. On for arraignment on 2 counts here today. Morning, Mr. Parker. All right, counsel, I did review probable cause. Anything you'd like to add on that, Mr. Lockhart?
No, Your Honor, I reviewed that earlier this morning.
All right, court does find PCs established for both charges at this time. Would you be prepared on the arraignment?
Yes, Your Honor, at this time, we are asking to waive a formal reading of rights, formal reading of the probable cause, and enter a not guilty plea on each of these 2 cases.
All right, thank you very much. Mr. Parker, at this time, I will waive any further reading then. Based on counsel's request, I'm entering a not guilty plea on your behalf to both charges that does preserve your rights and defenses. Mr. Kilfoyle, you wish to be heard on release?
Yes, Your Honor. I would note that not only are the facts rather alarming here, but the defendant has 5 prior DV assaults, once an A3, the rest are A4s. The defendant also has a prior conviction for physical control. It is back in 2006. Most of this history is somewhat older, but there is an aggregate of cases here that is quite alarming to the city, as well as the facts here: driving, assaulting a passenger, kicking the passenger out after slamming on the brakes and causing her to hit her head on the dash. At this point, the city is going to be asking for $5,000 cash, a court-approved performance bond. I would also be asking for a domestic violence no contact order. It doesn't look like the parties reside together, at least according to the information that I have. So we would just be asking at this point for just asking that the no contact order be put into place as it's written out. And then we would also be asking for pretrial monitoring with UAs. I know the BAC is low, it's 0.03, but it's still alarming combined with the assault allegation. So that would be the city's request at this time.
Okay, thank you, Mr. Kilfoyle. Mr. Lockhart, what's defense position here today?
And Your Honor, we're asking for a PR release subject to the no contact order. We would also be asking, if the court is going to impose bail on these matters, we would be asking for EHM in lieu of bail. And the reason I'm asking for that is that Mr. Parker is currently scheduled for double hip replacement here in September, but that does mean that he has a number of pre-op appointments with his surgeon coming up here in the next few weeks, in addition to having that obviously the surgery that's currently scheduled for September 5th. So there are a number of medical concerns here based on that. So we're asking for the release to EHM in lieu of that bail, subject to the no contact order, and certainly if the court requires scram as part of that, just to ensure compliance. I don't believe there would be an objection if that would be allowed for him to be able to get out and make sure he makes those medical appointments.
All right, well, I'm looking at Mr. Parker's history. I understand the medical issues, but this history is quite concerning. I mean, as recently as 2018, A3 is unlawful imprisonment DV, got numerous assault 4 DV convictions, multiple no contact order DV convictions. I can't justify a PR on this with that kind of history. The court is going to find that there is both a risk of a violent offense being committed and a risk of Mr. Parker interfering with the administration of justice based on those prior convictions. As for the Neg 1, I guess I'm not as concerned. It is obviously very low BAC. Looks like there is the one prior physical control from 2006, so I mean, almost 20 years ago. There is a reckless from 2011. I'm going to check. Does anyone know by any chance, was that a wet reckless, or was it just an outright reckless?
From my initial review, Your Honor, it just looked like an outright reckless, but I could be mistaken.
Okay. Well, I'm going to kind of split it up here then. In regard to the Neg 1, that is the easier one. The only driving related history is almost 20 years old. I am actually going to PR Mr. Parker on the Neg 1, but with pretrial supervision. The court would find I realize the pretrial supervision is really more in line with the A4, but it's going to be there regardless. So the court would find there's a nexus between substance use and the allegations here. Pretrial supervision will be ordered. And given the fact Mr. Parker's only driving-related history is almost 20 years old, and this is a neg 1 with a .03, I'll PR him on the neg 1. The assault 4, I am going to impose bail. There's the history that I already reviewed. I think some bail is frankly entirely appropriate. Given that overall history, I'm going to set it at $2,000. 10 times bondable is fine. But I think some bail and somewhat substantial bail is appropriate given the number of priors that I just saw. So that's going to be the court's order. The pretrial supervision, Mr. Parker, if you do post the bail, appear timely for court, have no new criminal law violations. You're not to drive without valid license, proof of insurance, have no drug or alcohol-related infractions, do not use or possess alcohol, non-prescribed drugs, or cannabis, don't enter any establishment whose primary business is the selling or serving of alcoholic beverages or cannabis. I am entering a pretrial no-contact order. That no-contact order is going to prohibit you from owning, possessing firearms, other dangerous weapons, although I think based on your previous history, you're probably already prohibited from doing so. And you will be subject to random testing at probation's discretion. I think that's everything as far as the conditions. I will obviously note any objection by the city is in regard to the amount of the bail, but I think that at this point that is appropriate. Mr. Lockhart, at this time, is it likely then that Mr. Parker would not be able to post that?
Correct, Your Honor. He's currently on Social Security disability, and will the court consider the EHM in lieu of that bail?
Yes. No, I'm sorry. No, not with that TV history. I'm not going to. The history speaks for itself, and I understand. Obviously, defense would object to that, but given that history, I can't justify EHM. It's lengthy and it's concerning. I will find Mr. Parker eligible for the public defender then. At this time, we'll get him an attorney on board. Mr. Lockhart, would you like me to order $10 bail on the neg 1 then, since he's going to be held on the other one?
Yes, Your Honor, just for nominal bail, and we can also let the court know that this will be a conflict, so we're sending it off to conflict counsel as soon as we get that referral.
Okay, I'll order the $10 bail on the neg 1 nominal bail so that Mr. Parker's getting credit on that while he's held. All right, I'm going to go ahead and set this out. I think given it's a conflict and given the history here, maybe to go to Monday, 8/11 instead of the sooner date.
That works for the city.
Let's do Monday, August 11th at 8:30.
Appointment.
And Madam Clerk, for a DB, was it 8/27?
And Your Honor, if we can perhaps set this to the 6th.
Sure. 9 or 8/6, you want it to be sooner?
Correct, just because if there is going to be a request for a temporary release, we would certainly be hopefully giving the conflict attorney time to be able to file that and get that submitted, just due to the fact that he does have that medical appointment on the 11th.
Well, he was healthy enough to batter someone, and with his DV history of holding victims hostage and, you know, everything else, I really don't think his hip surgery is the court's primary concern.
I guess I'm just concerned. I know that it takes a little bit of time to get conflict counsel on board. Do you think that's going to be able to happen by then?
I'll make sure that gets sent out to them as soon as we receive it.
Okay. All right. We'll do August 6th then at 8:30. And then the out of custody date will be 9/4, said Madam Clerk?
September 4th, Your Honor.
Yep.
5th is.
Okay, there we go. I'm going to go ahead and sign off on this. We do need to review the the no contact order. Mr. Parker, if you do post, I realize it sounds like it's unlikely, but if you do, you of course do need to report to the Whatcom County District Court Probation Department for that pretrial supervision that we discussed. As far as the no contact order here, it does protect a party by the name of Rebecca Percy. It does prohibit you from doing a number of things. It says do not cause, attempt, or threaten to cause bodily injury. This includes any type of assault, harass, stalk, or keep under surveillance a protected person. You're simply to have no contact with them. It's face-to-face, it's through a third party. It includes electronic and written contact, texting, phone calls, emails, social media. That stuff's all prohibited with them at this time. do not knowingly enter, remain, or come within 1,000 feet of the protected person's residence, school, workplace, vehicle, or wherever they may be. You're not to own, possess, control a firearm, as we discussed, and you will have to immediately surrender any of those items to the Bellingham Police Department. This order will remain in place until the case is resolved unless it's modified or rescinded in the meantime. Do you have any questions at all, Mr. Parker, about the no contact order? No. No? Okay, I'll take your silence as a no. All right, I'm going to go ahead and sign off on this. And Mr. Lockhart, that no contact order is ready for a signature.
What's the 2,000 cash?
10 times bondable as well, Mr. Lockhart, I wrote on there.
Yeah, so it's 200. No, that would be 2,000 cash or 20,000.
All right, thank you, Mr. Parker.
That's been signed.
Thank you, Counsel. Anything else ready, Counsel?
Brianna Johnson.
All right, we'll call the Johnson matter. I'll be just 1 second. Okay, let's try Johnson here. This would be cause number 5A06505774. This is on for an arraignment. Ms. Liu, good morning, Ms. Johnson.
Good morning.
All right, Ms. Liu, I did review probable cause. Would defense like to be heard on PC?
No, Your Honor, and we are prepared to waive the formal reading of rights and enter a plea not guilty today.
All right, court will go ahead. Court does find probable cause is established at this time for the charge. I will waive a formal reading of your rights, Ms. Johnson, at counsel's request. I'm going to enter a not guilty plea on your behalf. That does preserve your rights and defenses in regard to the charge. Mr. Anderson, does the city wish to be heard?
Yes, Your Honor, thank you. The defendant here, well, first of all, it does look as if there was alcohol involved, so the city is going to be requesting pretrial monitoring with UAs. The city is also requesting a no-contact order. As far as bail goes, the defendant does not have any Washington State history, but the NCIC did pull up history, including a prior conviction for assault from Michigan in 2016. There's also some theft history, larceny history there as well. Given that this is, there is a prior conviction for assault, the city is recommending $250 performance bail today. A little bit lower because it has been a few years. Did not appear that it was domestic violence related, but still is, at least it was 2 arrests, 1 resulted in a conviction for assault in 2016. So that's the city's recommendation today.
Thank you very much, counsel. Mr. Rodriguez, good morning.
Good morning. So I have the alleged victim here. He does want to address the court on his own, but I just wanted to note that he's not supportive of the no contact order. He believes that this is more of a mental health issue rather than anything else. He did note that there was obviously alcohol involved that contributed to the incident, but he is feels safe in her presence and asks that you don't post the order.
Okay, thank you. Good morning, sir.
Hi, good morning.
What does he like me to know?
Honestly, she's just been going through a lot lately. Over the last few days, she has been talking about something being off, and I don't know what happened or triggered it, but this is definitely more of a mental health issue. I'm perfectly fine. I'm safe. I don't feel like a victim. I just want to help her get the help she needs. And to do that, she needs a stable home, so I want her to come back.
Okay. Does she have anywhere else to go if the court were to enter an order today?
Her family's all down in Olympia, or Yelm, which is by Olympia.
The family's back. The family's not here, you said?
Right.
Okay.
Like, here we are each other's family.
All right. Thank you very much, sir, for being here. I certainly appreciate you taking the time to come and speak with me today. Ms. Lee, what's defense position here today?
Your Honor, first for the bail, Mrs. Biana has a part-time job and has very limited ability to pay for the $250. And for the no contact order, we will also ask the court to remove it.
All right. Well, as the city attorney noted in Washington, looks like very little history. I guess there is. You said there was 1 prior, Mr. Anderson, out of state?
Yeah, I was arrested for 2 counts of assault in 2016. 1 resulted in a conviction.
I was arrested.
Well, the court does have to take that into consideration. I think in regard to the bail, the city's request is actually probably pretty reasonable given there's a prior assault conviction. So the court is going to find there is a risk of a violent offense being committed. This is now a second.
And Your Honor, the city's okay with, if the court does, I was going to, come back in on the no contact order.
Oh, sorry.
The city's okay with if the no contact order not being put in place, if there is monitoring by probation. I think that's a good safeguard if the victim is, if the alleged victim is not interested in having the order in place. But I feel like there should be some
criminal history.
Some monitors given the alcohol.
The other in other states.
Understood. Thank you, counsel, and I appreciate you letting me know that. Okay, well, that's where I think I'm going to land then. So I do think the 250 is reasonable. There's a prior assault. We're going to have some bail posted.
Sorry, Your Honor.
Yes, Ms. Liu?
Yeah, so we want to recheck whether Mrs. Johnston has criminal history on Michigan. She said she's never been to Michigan.
I've been in Washington, Oregon. I was in Iowa for a couple months, but I've never been to Michigan in my life, Your Honor. I promise.
Okay, well,
I
counsel,
know.
the court can only go off the information that it has in front of it today. The city attorney has an NCIC that indicates criminal convictions from the state of Michigan.
I've never been to Michigan, sir.
So I understand where you're coming from, ma'am, but the court can only go off what it has, and the NCIC is a national database. Mr. Anderson, can you remind me who actually runs the NCIC program? Is it the FBI?
So the police, yeah, it's the FBI database with her name, date of birth. There has to be multiple identifiers. It says place of birth is Michigan, and it shows that. I
No, I was
obviously, if
born
that's
in
incorrect,
Arizona.
You have to contact the FBI to go through that because that's what's on her permanent record, unfortunately.
Okay.
So,
Okay, well, ma'am, that's certainly an issue that you can address with counsel. I understand. I'll note your objection. Again, I need to be clear. I understand you. I hear what you're saying. We have that NCIC, which is a report that the court generally relies upon. It comes from the FBI. It's a national database. So,
Did it say I was born in Michigan? Because I have a copy of my birth certificate saying I'm born in Arizona. I wasn't even born in Michigan. I was born in Phoenix, Arizona, Your Honor.
okay, Ms. Johnston, I hear you. I don't know what else to tell you, unfortunately. I understand there's a discrepancy here, but the court, again, I need to go off the report that I have, and that's the report that I have. 250, I think, is entirely reasonable at this point. 10 times bondable would be fine.
I'm sure getting in touch with the FBI to have that addressed is going to be super simple. I mean, there's got to be a 1-800 number FBI somewhere, or you can just at them on X and they'll respond. I'm sure of it.
The pretrial supervision, I think, is entirely appropriate. There's allegations of substance use here, specifically alcohol. And then the alleged victim has also indicated perhaps behavioral health issues. So I think that that's entirely appropriate. So court will order the pretrial supervision. Ms. Johnston, I'm going to go through all of that with you. Just bear with me for a moment. And the court will reserve on the no contact order at this time, given the city's stance and the stance of the alleged victim. All right, so the conditions, if you post the bail or bond, do you believe that she's going to be able to post the bail or bond?
Do you know if they take credit cards?
Use my
Sure, but it's going to be a 10 times bondable amount, so if you want to go through a bondsman, you can always just speak with a bondsman as well.
Okay.
So it'll be either a $250 cash amount or 10 times bondable. The conditions here: appear timely for court, ma'am, have no new criminal law violations. You will have to report to the Whatcom County District Court Probation Department upon your release from custody if the bail or bond is posted. They're located on the 4th floor of the county courthouse. That's the building directly next to the jail. You'll see them when you walk out the front doors. You're going to be looking at the building I'm talking about. So just head right next door, head up to the 4th floor. Conditions there. Again, the court has found there is a nexus between substances and specifically alcohol in this case and the allegations. So you're to have no drug or alcohol related infractions. You're to not use or possess alcohol, non-prescribed drugs, or cannabis, not enter any establishment whose primary business is the selling or serving of alcoholic beverages or cannabis, and you would be subject to random testing and probation's discretion to ensure compliance. Mr. Anderson, would you like me to have the behavioral health unit monitor Ms. Johnston, or are you fine with just standard?
I think just the alcohol for now.
Just the alcohol? Okay. All right, so those are going to be the conditions. Last one here, I'm not entering a formal no contact order at this point, but what I'm going to add is you're not to discuss the facts of the case with the alleged victim. So just don't talk about the case.
Okay.
All right, and then I guess this is a close call because I would assign someone counsel if they're not able to post the bail. You believe you're going to be able to have a bail or bond posted? Okay, all right. I'll go ahead and have Ms. Johnston review for the public defender online. You're always free to hire your own attorney, ma'am, if you wish to. You're not required to. And the application, the website link that you need to go to will be on this document. So just make sure as soon as you're out of custody to go online and apply for the public defender. Okay, we're going to set 2 court dates. At this point, I do technically need to set an in custody because we'll still require the bail or bond to be posted. At this time, that will be Monday, August 4th at 8:30. But then, Madam Clerk, what's a good Thursday afternoon? September 4th, 1:30 will be the out of custody date if that bail or bond is posted, and that'll be on the order as well. All right, I'm signing off on this, and I think that covers it. So, all right, Ms. Johnston, thank you very much, ma'am. Thank you, sir, for being here. I do appreciate your input.
Thank you, Your Honor.
Thank you very much, counsel. Okay, there we go.
Yes, Your Honor, we can call Jason Hansen.
All right, Jason Hansen, cause number 5A0638941. Morning, Mr. Hansen.
Morning, sir.
All right, this is on for pretrial. Ms. Lee, what is defense request here today?
Your Honor, Mr. Jason was recommended to do the treatment, and the bed dates open the first week of August. So today we will ask for a short continuance before August, and asking the court to grant him to finish the treatment.
Okay, well, we'll need a temporary release order for treatment, so you'll need to make sure to get that to the court. I'm not going to just write that into the order here. Make sure you get all that information provided, Ms. Liu. You know, when's the release date? What's the date Mr. Hansen's going to treatment? Where is he going? How is he going to get there? All the standard stuff. As far as the continuance, this order says August 4th. Is that not the date you want then? You want July?
Yeah, maybe July.
29th is the bed date, so.
Yeah, maybe July 23rd or July 28th. Which one is better?
July 28th. There's only 5 people on that Monday. Is there a
Okay.
speedy waiver being offered, counsel?
Yes, Your Honor.
Okay. Mr. Hansen, do you have any questions about that request then at this point?
I'm just a little confused. Just want to make sure. An attorney up here, he told me some different information, so I'm trying to understand what's going on. I don't exactly know what's happening.
Okay, I'll come back to you, Mr. Anderson, with the speedy waiver. Is there any objection to the 1 week from today?
No, that's fine. I mean, I guess my question is the anticipation is going to resolve and then go to try to be?
It's a good question.
Or is he trying to be TR'd while he's held on bail? I was under the impression it was going to be a resolution
and then go to.
Yeah.
We'll see if we can clarify that once council's done. So, Ms. Liu, Mr. Anderson asked, I think, a very pertinent question. Is the intention then that we set this for July 28th, and then is it going to resolve on that date before Mr. Hansen goes to treatment, or is the intention that he's going to have a TR to treatment and then come back to resolve the case?
Yeah, Your Honor, I talked with Owen last week, and he has concerns about how to transfer Mr. Hansen back from the treatment to the Whatcom County Jail. So we need more time to negotiate for possible resolution or TR motion.
Okay.
So, I mean, I'll just stay on the record. That's usually the city's preference that it be after the case is resolved. It's not desired to have someone released on a TR and then have them have to transported back to jail. So that would not, so that was the intention with our understanding, the negotiation to resolve today, but I just will say that's not our preference, is to have a TR where we have to transport back to jail.
Understood. Well, Ms. Liu, you've got a week to figure it out with counsel. I'm not sure. Are you the attorney of record on this, Ms. Liu?
I think so.
All right, I actually don't see an NOA entered yet.
Oh, we'll let the party.
Okay. Well, counsel, I'll make sure to get an NOA filed, whoever it's going to be from your office, and I'll grant you the 1 week. It sounds like the city is okay with that, and then we'll see where we're at next Monday. So the motion to continue is ready for signatures, Ms. Liu.
Okay, Your Honor.
What a little bitch. You're all taking it.
He wasn't assigned a public defender.
Well, somebody in the gallery certainly isn't happy with her performance. Oh my gosh. He said we're all thinking it. I didn't think it.
Okay, well, that creates a problem. Let me see. So, yeah, it looks like it was we did have a pro tem hear this. I'm just double checking. Yeah, I don't see anything. Okay, well, that makes it even easier. I'm going to have to I'll find Mr. Hansen eligible for the public defender. He's obviously in custody. We need him to have an attorney formally assigned. That would explain why there was not a notice of appearance. So
Okay.
Can you expedite that, Madam Clerk? Just make sure that gets sent right over to them.
So, I mean,
What is it, sir?
just really confused about what's going on, man. I've been lied to and kind of put off in the back burner here about what's going on. I'm just confused at what's happening.
So what questions do you have for me, sir?
What's going to happen? What's going on with me? How do I take care of this?
So we're formally assigning you an attorney right now. Ms. Liu's office is going to be getting that referral probably in the next 5 minutes. Their request today is to set the case over 1 week. That would be July 28th, 8:30. That is a Monday morning, just like today. Sounds like you obviously are trying to get to treatment. You're going to need to work that out with counsel. I'm not going to just sign an order without all the information. You need to have the information through counsel, submit an order, and then we can go from there. That's essentially where we're at this point. So you're going to need to speak with the attorney that's assigned here, Mr. Hansen.
Okay.
Do you have any other questions?
No.
No? Okay. All right. Well, I'm going to go ahead and sign off on this then. Mr. Hansen, thank you, sir. I'll see you a week from today. Okay. Ms. Liu, is anyone else ready to go?
Yes, Your Honor, we can call Matthew Spencer. This is a change of plea.
All right, Matthew Spencer, cause numbers 5A0155356, CV0115954. Morning, Mr. Spencer.
Good morning.
All right, I'm getting the paperwork pulled up. I do see that change of plea here. All right, this is going to be to 2 counts. Ms. Liu, I will need your signature when you're able to. This is going to be count 1,
Okay,
possession of a controlled substance. Count 2, criminal trespass, 2nd degree. Mr. Spencer, have you had the opportunity, sir, to review this document with counsel?
Yes, I have.
All right. Do you have any questions about it for me at this time, sir?
No, I don't.
All right. On the defendant's signature line, I do see a signature. Can you just confirm for the record, sir, did you sign off on this?
Yes, I did.
All right. Thank you. Do you understand, sir, that by pleading guilty to these 2 charges, you are waiving your rights, including the right to a jury trial and the right to remain silent?
Yes, I do.
All right. Let's take a look at the recommendation then, Mr. Spencer. We've got on count 1, that's the controlled substance charge, 180 days, suspending 175, so that'd be 5 days. Credit for time served on that. Looks like you've been booked since 6/28, so you should be well beyond credit on that. $150 fine being recommended. Count 2, pretty much the exact same. 90 days, suspending 85, so another 5 days, $150 fine. And that is it. There's no request for probation here. So serve the 10 days, pay $300. Is that your understanding, Mr. Spencer, of the recommendation?
Yes.
All right. And do you understand the court is not required to follow that, sir, and could sentence you anywhere up to the maximum penalty?
Yes.
All right. Other than that recommendation we just reviewed, has anyone promised you anything or threatened you in any way in order to get you to plead to these?
Nope.
Are you doing it today on your own free will? I can see you shaking your head, but I need a verbal confirmation.
Yeah. Yes.
Thank you. Sorry, it's just because we're being recorded, sir, so we just need to have the audio. Thank you very much.
problem.
Lastly, sir, do you also understand that if you're not a United States citizen, conviction of these crimes could carry negative immigration consequences?
Yes.
Thank you, Mr. Spencer. Ms. Lee, are you satisfied your client is making the change of plea freely, voluntarily, and intelligently with full knowledge of the consequences?
Yes, Your Honor.
All right, thank you very much. Mr. Spencer, on count one, it's cause number CV0115954, charge of knowing possession of a controlled substance. How do you wish to plead today?
Guilty.
And on count two, cause number 5A01555356, charge of criminal trespass, second degree. How do you plead today?
Guilty.
Thank you very much. Counsel, are there stipulations to facts sufficient on both?
Yes, Your Honor.
All right, with those stipulations, court does accept your guilty pleas, Mr. Spencer, finding that they're made knowingly, voluntarily, and intelligently with full knowledge of the consequences. There is a factual basis to support both the guilty pleas, and the court has now entered those findings of guilt. Mr. Anderson.
Thank you, Your Honor. The defendant was held on these two matters plus some Superior Court cases, which it looks like, according to Mr. Good's notes, were dismissed. So these are the only things that were holding him. The city's offer is just to plead to both with 10 days total, no probation. Just ask the court to follow that recommendation as part of a sort of resolution of all of his matters.
Thank you very much. Ms. Leo, does defense wish to be heard?
Yes, Your Honor. All the other cases were dismissed in the Superior Court and District Court, and we will ask the court to follow the court's recommendation today. Thank you.
Okay. Mr. Spencer, sir, keeping in mind you don't have to say anything, is there anything you want the court to know at this time?
No.
Okay.
We'll just chalk off the other 2 months I served. The 9 days.
Yeah,
All right,
unfortunately,
thank you.
Mr. Spencer, with the Superior Court stuff, I obviously have no jurisdiction over that. So you were held on that as well. But at this point, yeah, I'll go ahead and follow the recommendation, Mr. Spencer.
All right, thank you.
All right, just sit tight. I know you're ready to move on, but I've got to go through it all with you. So, going to be pretty straightforward. I'm going to follow the recommendation. 180 days, suspending 175. It's 5 days, credit for time served. In regard to any fines, I do need to ask you some questions before I can impose the fines. Are you currently employed, Mr. Spencer?
Nope.
When was the last time you were employed?
A while back.
Are we talking years or months?
I'm on retirement right now.
Okay. Are you receiving public benefits like food stamps or Apple Health Care?
Yeah, and I have private too.
Okay. Last question then is in regard to your income, you said you're receiving retirement benefits. What's that through?
Through family stuff. I can afford like $50 a month. 50 or 100.
Here's what I'll do. I'll go ahead. It sounds like there's some ability to pay court costs. I'll impose. I'm going to have the fine. One of the fines I'm going to suspend. So I'll say no fine on count one. Then on count two, it'll be as recommended, 90 days, suspending 85, so 5 days there. And then I will leave the $150 on that one. So $150 fine will be the total based on your representation by the public defender. I will waive any other non-mandatory legal financial obligations. Mr. Spencer, you said you can pay up to $50, but are you fine? I'll set it at $25 per month, and you can always pay more if you're able to.
All right, thank you. That's fine.
All right, we'll do.
Yes, that's fine.
First payment due in about 60 days by September 22nd. You will need to contact Signal Management to get those payments set up, sir. They're the third-party vendor our court uses to collect payments. All of their information is on the paperwork, which you'll get a copy of under the heading of payment options. So just make sure to give them a call. That should cover it, so I'm going to go ahead and sign off. Do you have any other questions for me, sir?
No, sir.
All right, thank you very much for your time, Mr. Spencer, and good luck to you. Carr, okay. Deputies, do we have Mr. Carr in the courtroom by any chance?
Mr. Carr is here. Carr? Lucas Carr? Yes, Your Honor, he's here.
Okay, we'll take Mr. Carr then. We've got Mr. Powers in Zoom, so I think he's appearing on that one.
Okay.
Calling Lucas
Sure,
Carr,
yeah.
cause number 5A03858184. Good morning, Mr. Carr.
Good morning, Your Honor.
Will be just one moment. Your attorney's appearing via Zoom. I'll just make sure that he is present and able to hear me. Mr. Powers, can you hear me in Zoom?
Good morning, Your Honor. Dylan James, President, on behalf of Mr. Carr.
Great. Good morning, counsel. All right, so
Good morning.
we are here. Technically, we have, I think.
Your Honor,
Yes?
is it not Ms. Trainer, my attorney?
I don't know if you have an attorney out of another jurisdiction. Mr. James Powers is your attorney here in Bellingham.
We've established contact.
I thought it was
Mr. Carr.
Miss-
How are you?
I'm fine, Mr. Powers. I thought my attorney was Miss Mary Kay Trainer.
It's probably your Superior Court attorney, sir. You have cases out of Whatcom Superior Court and cases out of Bellingham. They have two different public defender's offices, two different, I guess Mr. Powers is actually a conflict attorney. He's not with the public defender's office. But, yeah, so it's going to be a different attorney than your felony charges.
That's what happens when you rack up multiple charges in multiple areas.
Oh,
Okay. All right. So we have actually pretrial violation alleged as well. That was entered as a denial back on June 23rd. So let's start there. Mr. Powers, are we able to resolve that today, or are you maintaining the denial?
Not today, Your Honor. The defense will maintain the denial and ask for a continuance.
Okay. I'm pulling up the motion to continue here. It is not currently filled out, so where do you want it to go, Mr. Powers?
Your Honor, let's set it over a week.
Okay. Is there a speedy trial waiver?
There is not.
The city would request trial dates. This was already set 2 weeks without a waiver. We don't have enough time. So I think we just need to set trial dates at this point.
I think, yeah.
Unfortunately, I understand the position, but we just don't have speedy. He's already not waived for the last 2 weeks. Can't waive for another week.
I don't know who is in the courtroom over there yelling obscenities, but you're going to be removed from the courtroom if you don't stop. I'm going to give you one more chance, and then we're going to have you removed. All right, so I just need to make sure. Are we running from 6-2 then?
6:23, actually, I believe.
Okay. Just double checking here, 'cause we had...
Maybe, no, it might
Oh,
actually
actually,
be,
no,
it
it's-
might actually be 6.
I actually see on 6:23 it says speedy commencement 7-7. So we're running from 7-7.
That's not true, though. I see that in the docket, too. That's an error by the clerk, because if you go to the paperwork, because I wrote it that day on 6:23 that it was not waived, and
Okay.
that is correct, because there's.
It was
back
not
to the
waived.
document on, excuse me, hang on. Back to the document, and I don't think there was a waiver.
That is correct. There was no speedy waiver on the 23rd.
I think we have to, Miss McGrain calculated, she thought we had till 8:22.
6:23. Yeah, it sounds right then. 8:22. Okay. All right. Well, at this point, I mean, we are pretty much a month into our 60-day time for trial. If there's no resolution, then I would have to agree with the city attorney. We just need to set it for trial. So,
Let's set it for trial, Your Honor.
all right. I'll give Mr. Anderson just a moment. Do you have any proposed dates, Mr. Powers?
I do not, Your Honor.
All right. I'll pull up a pretrial conference form here. And this will obviously be dependent on the city's witness availability, but.
Yeah, let's just go ahead and set the dates. There's just too much
Okay.
for us. And then Miss McGrain will have to communicate with council if there's any issues there. It's also going to be tough because
All right.
August is going to be tough.
You're
But
right.
yeah, just maybe first or second, maybe second week of August.
Yeah, okay, just pulling it up right now. So, Mr. Carr, we're just gonna set a jury trial date at this point. You wanna do August 12th then, Mr. Anderson?
That works.
Does that work for defense as well, Mr. Powers, August 12th?
That works for the defense, Your Honor. Thank you.
All right, I'm filling out
Yeah.
the order.
And Mr. Carr, I will give you a call after court, okay? Please don't say anything on the record. All of these proceedings are recorded, okay, brother?
sounds good, Mr. Powers.
All right, status will be the day before. That'll be August 11th at 8:30. Then that would put readiness, I believe, on the 28th, so next Monday, okay? Well, readiness is gonna be on this coming Monday then, July 28th at 8:30. I'm gonna indicate, readiness and status will be at 1:30 PM if Mr. Carr is out of custody on those 2 days. Are both parties just reserving on motions at this time?
At this time, yes.
The defense will reserve.
All right, I'm out of the order. You'll probably need to refresh, but there's a pretrial conference form there that should be ready to go with all of those dates. Mr. Carr, sir, do you have any other questions for me?
No, Your Honor.
Okay, perfect. So it sounds like Mr. Powers will be calling you very shortly, so just make sure to stay in touch with him in regard to this case. Otherwise, sir, we will see you then on July 28th. That's next Monday for readiness.
Oh, all right.
Thanks, Mr. Carr.
Thank you, Your Honor.
Appreciate it. Okay, not sure it makes a huge difference, but Madam Clerk did pull up the motion to continue from June 23rd, and it does have a speedy
That one?
waiver
But to what date?
to commencing on 7/7. So
Okay,
we're 2
I mean, it
weeks.
still gives us more time, but it's still, he didn't waive from 7/7 to today, that's still 2 weeks.
Understood.
Yeah.
Just letting you know.
Yeah, no, gotcha, okay.
Okay, all right. Those dates will remain the same. I'm signing off on the order. And Ms. Liu, did you have anything else ready to go?
Yes, Your Honor, we can call Terry Kinney.
All right, we'll take the Kinney matter. I'll be just 1 second. I'm adding one last thing to the prior order. Morning, Mr. Kinney. All right, this would be cause number, two of them, CB 01091616 and 480652703. These are both on for pretrial here today. Ms. Liu, what is defense request?
Your Honor, today we are asking a short continuance for possible resolution with speedy trial waiver.
This was a warrant return, so I guess we do need to address that. Mr. Anderson, does the city wish to address conditions at all?
Yeah, I think the city would have to just maintain bail today. He is Bellingham only, holds, the warrants are obviously out for a bit. Case one of these cases is from 2020, the other is from 2024. I'd ask to maintain bail at this point. The defendant's offer is only 5 days. So I do think maybe we could set, if they don't want to resolve today, I mean, he'd be close for defense serve. I don't know what Wednesday look like, but.
Okay. Ms. Liu, do you think we can get this wrapped up on Wednesday, or do you want to go on to next Monday?
Wednesday is,
Fine.
yeah, Wednesday works for us, Your Honor.
Okay. So, Mr. Kinney, I am going to maintain the bail. One of these cases is from 2020. It's a 5-year-old case, and there's been a number of failures to appear. So I think that the bail that was ordered on the warrant at this point probably is perfectly reasonable given those failures to appear. So that'll be maintained. I'm going to find you eligible for the public defender if you don't already have one assigned. And I'll just set this over to Wednesday morning, the 23rd. It sounds like for a likely resolution based on.
And I do think there's already been attorneys, I think it was, even though the cases are old, I think it was a more recent FTA, so we've already communicated, and he does have an attorney.
Got it, okay. Madam Clerk, could you delete the continuance since I'm doing this on a control order? All right, I'll be just 1 minute, Mr. Kinney, I'm just finishing up the order here.
Is there any way I can get out today?
All right, and Madam Clerk, what is a good out of custody date? Out of custody date will be September 9th. All right, there we go. Mr. Kinney, thank you, sir. Do you have any other questions for me?
Yeah, is there any way I can get out today?
Not today, sir. And the reason being, Mr. Kinney, I just want to be clear, both of these cases have had active bench warrants. One of these cases is from 2020. The other one's from 2024. The court at this point is finding that there is clearly a risk of flight. I understand. Unfortunately, you just haven't.
I haven't ran anywhere. They just don't tell me.
Mr. Kinney, I understand, but at this point, the record that I'm looking at is pretty clear. You just haven't been coming to court on these cases. So in order to assure your appearance in court, I'm going to maintain the bail that was on the warrants.
Yeah, if I can remember going to court on Wednesday, but if it's longer than a couple of weeks, then I can't remember. And so I space them out.
That's unfortunate, Mr. Kinney, but that's part of the problem, it sounds like. We're going to see you on Wednesday morning, Mr. Kinney, if there's a different outcome.
Oh, shit, we're locked up, jackass. All right, fine, thank you.
Okay, well, Mr. Kinney, hopefully you don't have that type of attitude on Wednesday, because any further language like that, and the court's going to seriously consider contempt proceedings at this point. But I'll sign off on it today. All right, Mr. Lockhart, is anything else ready to go?
Yes, Your Honor. We can call the matter of Terry Kinney. 2 cases.
All right, Terry Kinney, cause number CV 01096116 480652703. It's on for pretrial today, set over from Monday morning, I believe. Mr. Kinney, good morning, sir. All right, counsel, how are we proceeding today with Mr. Kinney? Change of plea?
Yes, Your Honor, there is.
All right, thank you. I just saw that. Sorry about that. Okay. All right, Mr. Kinney, I have a guilty plea statement before me to 1 count. It's possession of a weapon capable of harm. Looks like pursuant to that guilty plea, the city is going to move to dismiss trespass 2nd degree. I do just need to go through a few questions with you, sir. Have you had the chance to review this document with counsel?
Yes.
All right, do you have any questions about it, Mr. Kinney?
No, sir.
All right, on the defendant's signature line, I do see a signature. Can you just confirm for the record, sir, did you sign off on this?
Yes.
All right. And Mr. Kinney, are you aware that by pleading guilty to this charge, you're waiving your rights, including the right to a jury trial and the right to remain silent?
Yes, sir.
He's a completely different person today.
All right, let's take a look at the recommendation, sir. It says 364 days, suspending 360, so that would be 4 days. Credit for time served towards that, which the jail will calculate. Looks like you were booked on the 20th, so you are well within, pretty far into that. I don't know if you'd be released today or tomorrow, but you're very close. Fine being recommended is $300, Mr. Kinney. Other than that, no probation, really nothing else. So serve the 4 days, pay $300. That is the recommendation. Is that your understanding of it at this point, sir?
Yes.
All right, and do you understand the court doesn't have to follow that and could sentence you anywhere up to the maximum penalty?
Yes, sir.
All right, other than that recommendation we just reviewed, Mr. Kinney, has anyone promised you anything or threatened you in order to get you to plead to this?
No.
All right, you're doing it on your own free will?
Yes.
Okay, and lastly, sir, are you also aware that if you're not a United States citizen, conviction of the crime today could carry negative immigration consequences?
Yes.
Thanks, Mr. Kinney. Mr. Lockhart, are you satisfied that your client's making the change of plea freely, voluntarily, and intelligently with full knowledge of the consequences?
I am, yes, Your Honor.
All right, thank you, counsel. Mr. Kinney, on cause number CB0109616 to the charge of possessing weapons capable of harm, how do you wish to plead today, sir?
Guilty, Your Honor.
Thank you very much. Counsel, is there a stipulation of fact sufficient?
Yes, Your Honor, there is.
All right, with that stipulation, court accepts your guilty plea, Mr. Kinney, finding that it is made knowingly, voluntarily, and intelligently with full knowledge of the consequences. There is a factual basis to support the guilty plea, and the court has now entered that finding of guilt. Mr. Coupe.
Thank you, Your Honor. Your Honor, this is an agreed recommendation between the parties. Pursuant to the guilty plea, the city is moving to dismiss the 703 cause number with prejudice at this time. The display of the weapon charge from November of 2020. The defendant had pulled a machete on the owner of a grocery outlet here in the city of Bellingham. Thankfully, nobody was hurt, but that's still behavior that's unacceptable here. So I do believe the 4 days is appropriate. It doesn't look like he had any related priors. He does have other history, but nothing related to that. So
What would cause you to pull a machete on a grocery store owner? I can't imagine the circumstances leading up to that. I mean, I know eggs are expensive. I get it. You know, you probably had the machete on you to slice your lemons for your sparkling water, but you just can't turn it on the shop owner.
this time, I would just ask the court to follow the agreed recommendation.
Thank you very much, counsel. Mr. Lockhart, would you like to be heard at all?
And Your Honor, this is an agreed recommendation. I would just ask the court to follow it today. I can let the court know that Mr. Kinney is currently homeless. He does not have any income coming in. I don't believe that there's an ability to pay any current or future fines in this matter, and just wish him the best of luck going forward.
Thank you very much, Mr. Lockhart. Mr. Kinney, sir, keeping in mind you don't have to speak at all. You do have the right if you'd like to. Is there anything you want me to know at this point?
No, Your Honor.
No. Okay. All right, Mr. Kinney. Well, I'm certainly going to follow the recommendation. I'm looking at your history right now. A couple of prior convictions, but nothing specifically related to this. So, given that, I'm going to follow this. It makes total sense to me, Mr. Kinney. Let's go ahead and just walk through it together. It will be 364 days, suspending 360. It's 4 days, as I said earlier. Credit for whatever time you have served. Looks like you're about 3 days in, so the jail will calculate whether there's any good time. In regard to any fines, I'm going to confirm a couple of things Mr. Lockhart indicated here. I just want to make sure, sir, you're not currently employed at this time, Mr. Kinney?
No, sir.
Has it been a number of years since you have been?
Yes, quite a few, sir.
Okay. And you don't currently have any income?
No.
Okay. I'll make the finding of indigency. The court does find that there's not a current or really future ability to pay these non-mandatory court costs, so I'm not going to impose them. $5,000, suspending all $5,000, I'll waive the conviction fee as well. So serve the 4 days. You don't owe any fines or court costs, Mr. Kinney, and then at that point you are done with this case. Do you have any questions for me, sir?
No, sir.
All right, I'm going to go ahead and sign off on the paperwork. I guess I didn't say it, but hearing no objection, the city's motion is granted. The trespass second degree on the 703 cause number is dismissed at this point. So, all right, I'm signing off. Mr. Kinney, thank you again for your time, sir, and good luck to you.
Thank you.
Thank you.
Your Honor, it sounds like we'll be able to call the matter of Jonathan Fairclough.
All right, Jonathan Fairclough. Number of cases here, 480539941, 480539940, 3802968833, 3802968831.
Oh, and I apologize. He might be speaking with counsel right now.
Oh, is he?
So why don't we call the matter of Julian Bryant?
Thank you. All right, Mr. Lockhart, who else is ready to go?
Your Honor, we can call the matter of Kyle Coupe.
All right, Mr. Kyle Coupe, cause number CB0114407. Morning, Mr. Coupe.
Morning, bro.
All right. Okay. Mr. Coupe, let's go ahead and get started. This is technically a warrant return, I think, but I think we're also, it looks like a change of plea, Mr. Lockhart.
There will be, Your Honor. So we would ask to quash the warrant pursuant to the change of plea.
Okay. Looks like, actually, I think it was returned. Did we get it back, Madam Clerk? Great. All right, we can just get started then. Mr. Coupe, I have a guilty plea statement to criminal trespass second degree. Have you had the opportunity to review this document with counsel?
Yes, Your Honor.
Thank you very much. Do you have any questions about it for me at this time, sir?
No.
All right, I can see a signature there on the defendant line. Can you just confirm for the record, Mr. Coupe, have you signed off on this?
Yes.
All right, and do you understand, sir, that by pleading guilty to this charge, you are waiving your rights, including the right to a jury trial
Yes.
and the right to remain silent? Yeah?
Yes.
Okay. Recommendation here, sir, basically 1 day. It says 90 days suspending 89, so 1 day in custody, credit for time served towards that, $150 fine, and that is everything. There's no probation. So that's the recommendation. Is that your understanding of it at this point?
Yes, Your Honor.
All right, and Mr. Coupe, do you understand the court is not required to follow this and can sentence you up to the maximum penalty?
Yes.
Other than that recommendation we just reviewed, has anyone promised you anything or threatened you in any way in order to get you to plead to this?
Negative.
Are you doing it on your own free will?
Yes.
Okay, and lastly, sir, are you also aware that if you're not a United States citizen, conviction of this crime could carry negative immigration consequences?
Yes.
Thank you, Mr. Coupe. Mr. Lockhart, are you satisfied Mr. Coupe's making the change of plea freely, voluntarily, and intelligently with full knowledge of the consequences?
I am, Your Honor.
Thank you, counsel. All right, Mr. Coupe, on cause number CB0114407 to the charge of trespass second degree, how do you wish to plead here today?
Guilty.
Thank you very much. And counsel, it looks like there is a stipulation of fact sufficient.
Yes, Your Honor.
All right, with that stipulation, the court accepts your guilty plea, Mr. Coupe, finding that it is made knowingly, voluntarily, and intelligently with full knowledge of the consequences. There is a factual basis to support that guilty plea, and the court has now entered that finding of guilt. Mr. Kilfoyle.
Thank you, Your Honor. Your Honor, this is an agreed recommendation between the parties. Mr. Coupe has one prior conviction for criminal trespass in the first degree. Our case arose on April 14th of 2025. The defendant had been trespassed from the 1331 Commercial Street property just the day before, and then the day later, same law enforcement saw him there and arrested him for criminal trespass in the second degree. Pretty straightforward. He's credit for time served at this point. It would just be the $150 fine. I would ask the court to follow the agreed recommendation.
Thank you very much, counsel. Mr. Lockhart, anything from defense?
And Your Honor, this is an agreed recommendation, so we would ask the court to follow it. I can let the court know that, based on his appointment to us, I don't believe Mr. Coupe is in a position to pay any of the legal financial obligations, either currently or in the near future. Thank you.
Not in a position to pay the legal fees, but this guy is comically identical to every pizza delivery character I have ever seen in my life. Like, seriously, if you hand him a pizza box, you would never know that he didn't work for a pizza delivery outlet. I am shocked.
Thank you, counsel. Mr. Coupe, you don't have to say anything, but you have the right if you'd like to. Is there anything you want me to know at this time?
No, Your Honor.
All right, Mr. Coupe, I've looked at your criminal history. Given what we have here, I have no reason to differ from the recommendation, so I'll follow it. 90 days, suspending 89. It's 1 day, credit for time served. Looks like you're probably beyond credit at this point, which the jail will calculate. In regard to any fines, I do need to ask you several questions. Are you currently employed, Mr. Coupe?
No.
All right.
Yes, Pizza Hut.
All right, do you receive any public benefits, food stamps, Apple Health Care, anything like that?
Yes.
Yeah, okay. Any source of income at this time, sir?
No.
All right, I'll make the finding of indigency. I'll find there's not a current or future ability to pay these court costs. I'm not going to impose non-mandatory legal financial obligations. So the fine will be $1,000, suspending all $1,000. The conviction fee is waived. Essentially serve the 1 day, which I believe you have, and you have no further obligations on this matter. Any questions at all from you, Mr. Coupe?
Nope.
Thank you for your time, sir. Good luck to you. All right, Mr. Lockhart, who else is ready to go?
The next matter I can call, Your Honor, is going to be the Shoshana Nook Smith.
All right, we've got cause number CB01070854, 4A0797323. Good morning, sir.
It's Sinanik Smith.
I was gonna ask you, how do you say your name, sir?
Sinanik Smith.
Sinanik Smith. All right.
Yeah.
Great. Good morning, Mr. Smith. Thank you for letting us know how to say your name. I was curious myself. So, all right. I got to call the rest of the cases here real quick. Cause number CB0114127, 9Z0892304, CB0104071, CB0115881, and 5A02333706. I think these are all warrant returns, or was there one that I think they are?
They're all warrant returns.
Okay, all right, so let's start with the arraignments then, Mr. Lockhart. We obviously have, looks like 1, 2, 3, 4, 5, I think, arraignment cases. Are you prepared on those?
Yes, Your Honor. At this time, I'd waive a formal reading of rights. We did sign off on those. Waive a formal reading of the probable cause, which was established at the FTAs, and asked to enter not guilty pleas on his behalf.
All right, thank you very much. Mr. Smith, I'm going to go ahead and waive any formal readings at this point of your rights and the charges. Sounds like you've reviewed those with counsel. I'll enter not guilty pleas on your behalf as to all of the new arraignment cases. It does preserve your rights and defenses in regard to those. A couple of these cases were already in pretrial status, so you'd already gone through arraignment on them. Give me one moment, Mr. Kilfoyle. I need to kind of go through and enter the not guilty pleas because I need to sort through them, and then I'll hear from the city under release conditions.
That's fine, Your Honor. I'm going through the essential elements right now.
Thank you. All right, there we go. I think I've got everything entered. If you are ready, Mr. Kilfoyle, go ahead on conditions.
Thank you, Your Honor. At this time, I would note for the record the defendant has also now been booked on a retail theft special circumstance. A lot of these matters are shoplifting and theft related. At this point, I would just be asking the court to maintain the bail that was imposed by the warrants. I think that's completely appropriate. I would just also note for the record that these cases go back years. The oldest one is 2019, 2024, and 2025. I think that most of these were set at appearance bonds, so I think that would be completely appropriate.
I think they all. So, okay, so just mentioning the warrant announces the request.
Yes, sir.
Okay, Mr. Lockhart, would defense like to be heard on that request?
Yes, Your Honor. So we would just be asking for, first of all, just a PR release. I know that most of these mail have been returned undeliverable, although I did note that at some point in time there was a request for a bench warrant clock hearing. I can let the court know that Mr. Smith is not currently working. There's no current income. He does receive EBT and other state benefits. He's been in the area for over 30 years, and that all of his family, friends are in the area, so there's certainly ties to the community here. So we just have the court take all of that into consideration. Thank you.
Thank you.
Sometimes listening to what's going on in the gallery behind the defendant is just as entertaining as what's going on directly in front of us in the courtroom.
Well, these are all nonviolent offenses. What the court is considering, though, some of them are very old. I mean, we're going back 2019 for the pre-trials. There obviously was notice of those because they were in pre-trial status. Mr. Smith was arraigned. And then really just subsequent shoplifts and thefts. Court is finding there's clearly some flight risk based on the fact that those 2019 cases had active warrants and there was actual notice of all of those. I'm going to go ahead, based on that finding, I think I'm just going to make these kind of uniform. I'm looking at the amounts, they kind of varied all over the place. I see 2,000, 1,500, 5,000, 500. I think what we'll do here, we've got, how many charges? 1, 2, 3, 4, 5, 6, 7, 8, 9. I'm just going to set it at $1,000 bond on each. It's going to be $9,000 bondable at this point. This is going to be straightforward. So that's going to be the order. It's all bondable, sir. I'll allow for a $900 cash alternative. But given the age of some of these cases and frankly just how many cases there are, the court thinks that certainly bail is appropriate at this point. So that will be the order here. Otherwise, just standard conditions. That'd be law-abiding behavior. Don't pick up any new charges, Mr. Smith, and make sure to come to court. In regard to the driving charges, don't drive without a valid license and proof of insurance.
I haven't been or anything.
Okay,
Like those.
That's good, Mr. Smith. I'm glad you haven't been driving. I can see that you don't have any new driving suspended charges. I'm just indicating one of the conditions of release is not to drive without a valid license and proof of insurance.
Yeah, I wouldn't.
All right. So, Mr. Smith, that's going to be the court's order. I'm just finishing it up right now. Mr. Lockhart, I guess, the court's been, I think you were gone during this. The court's kind of made a decision that's going to be a little more strict in terms of assigning counsel, but Mr. Smith is obviously in custody with bail imposed. Do you think he's not going to be able to post that?
I don't believe so, Your Honor, just based on the lack of income. I don't think that he's in a position to post this bail, and I don't think he's been seen by Superior Court yet, so I don't know what they're going to be setting on that one.
Okay. In this circumstance, Mr. Smith, then I will find you eligible for the public defender, since we do have a bail amount imposed here, and you also have a Superior Court hold. We'll get you an attorney assigned, and then we're going to set 2 court dates for you, sir. One will be in custody, one will be out of custody. The in custody date will be on August 6th at 8:30. That's exactly 2 weeks from today. And Madam Clerk, where are we going for out of custody? September 12th at 1:30 will be the out of custody date, sir.
How long is that one?
The out of custody date, September 12th, that's about a month and a half from now. The in custody date is exactly 2 weeks from today, sir. Here we go. Okay, Mr. Smith, thank you, sir. Do you have any other questions for me?
No.
All right, thank you, Mr. Smith.
Thank you.
Yes, Your Honor, we can call the matter to Sanic Smith.
All right, it's cause number CB0115928. Morning, sir. I realize I asked you the other day how to say your first name, but can you remind me? Sananik. All right, Mr. Smith. Sananik Smith. This is on for an arraignment, and I believe this was a felony drop-down, right? Is that what this was?
On Mr. Smith's case?
Yeah. Or is this just a new charge? Because I know we saw him the other day, and I think he had a retail theft that was...
This is a drop down. This was a retail theft.
Okay. All right. Okay, Mr. Lockhart, I just looking at PC right now. This is actually the only one I only just got as we were walking into court. Looks like there would be probable cause. Did you wish to be heard on that at all?
No, Your Honor, reviewed the PC earlier this morning.
All right, I do think there's probable cause for the new charge. I'll go ahead and find that. Mr. Lockhart, are you prepared on the arraignment then?
Yes, Your Honor. At this time, we would ask to waive a formal reading of rights and then just enter a not guilty plea on his behalf.
All right, Mr. Smith, I'll go ahead and waive any further reading. I am entering a not guilty plea on your behalf that does preserve your rights and defenses in regard to the charge. Mr. Kilfoe, does the city want to address conditions?
Yes, Your Honor. All the other matters that we heard the other day were all set at a $1,000 appearance bond or a $100 cash alternative. I would just be asking to match that at this time.
All right, thank you. Mr. Lockhart, anything from defense?
Your Honor, we'd just be asking for perhaps a $10 nominal bail on this matter.
All right, well, court's going to just make the same findings that it made previously. These are nonviolent offenses. This is a nonviolent offense, but there is pretty extensive warrant history and dating all the way back to 2019. That's why bail was ordered in all those other cases. I think $1,000 bondable is perfectly reasonable here. I'm just going to mirror everything at this point. We've got, I don't even know how many pending cases. It's a lot. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 pending cases. So I think that's more than reasonable given that sheer volume. Madam Clerk, did I find Mr. Smith eligible for counsel earlier this week?
I thought I was getting PR.
No, Mr. Smith, when I saw you on Wednesday, you were, or Monday, I don't remember which day it was, the court had imposed $1,000 bond on all of your matters, $100 cash alternative on each of them. Court's doing the same thing. I did. Okay, so it looks like, Mr. Smith, I'll find you eligible for counsel on this.
You have 10 pending cases, sir, and you expected a PR bond after you didn't get one on Monday? You thought Wednesday you were just magically getting PR'd with 10 pending cases.
And that is due, again, really to the sheer volume in your appearance history, Mr. Smith. So the total between all 10 cases would be a $10,000 bond or a $1,000 cash alternative. And just to be crystal clear, that's only due to flight risk and, again, the sheer volume of how many cases are pending at this point.
I couldn't get here today.
You're not getting PR today, sir. The conditions will be as follows, Mr. Smith. Appear timely for court, have no new criminal law violations. And then, Madam Clerk, what day in custody? Well, actually, I guess both in and out. What did I set him to? August 6th will be the in-custody date to track along with Mr. Smith's other cases on that date. September 12th is the out of custody. All right, I'm signing off on that. Thank you, Mr. Smith.
All right.
Yeah. Good to go. Thank you. Okay.
Oh my gosh, that was too much fun. I absolutely. Oh my gosh, over 2 hours with you guys. That was so great. And I just uploaded a video, a short, while I was streaming. Here, you're not gonna let me close it, are you, Bandit? No, you're not. I know. So while I was streaming, I got an alert, a human alert. It literally says on my doorbell cam, human alert, right? And the only thing when I loaded it up, hold up, you got to see this. Okay, let me get it back here. And then share screen. Okay, so yeah, it alerted me of a human. And the only thing I see is that orb that just flew by. And this is not the first time that that has happened. It's not dust. You can tell it's not dust because it's transparent and it just, the way that it just flies right by. Yeah. So that was wild. The judges or the spirits are playing ding dong ditch on my doorbell cam. Oh, he's wonderful. I really like him. I have played him before, but I don't run Bellingham too often. I do work them in though. But yeah, that's a really great courtroom. It was Tinkerbell. Oh no, it was way too tiny to have been a drone. It was just an orb. It was transparent, translucent, like you could see right through it, but it was a perfect circle. And the alert went off, and I clicked on the camera, and that was the only human there. And like I said, it's happened before. It happens. I don't want to say often, but it's been a few times where the absolute only thing on my camera is an orb. All right, guys. Thank you guys so much for coming out and hanging out with me. This has been a blast. I had so much fun. And I really love that it's not 2 a.m. right now. It might be. It might be. Oh, Buzzy Pug, thank you, sweetie. That means a lot to me. How wee baby girl. Look at her. She just had to get up here. She had to get up on my leg so her sweet face could be here when I say goodnight to all of you. It sure is. We've got the best community. I appreciate every one of you. Be safe, be well, sleep sweet, and much love.